Now, I did wonder about the ethics and good taste of making a video on the back of somebody trying to shoot Donald Trump. But then I thought, actually, he's a bit of a business guy and he understands, seizing an opportunity. In fact, he'd probably appreciate this, and it wouldn't surprise me if he was actually saying, hey, go for it, Al, and tell your people, don't forget to like and subscribe. Sorry, it's really bright here, putting the shades on. But what do I want to talk about, and why is it relevant? Well, all the laws we have in this country and most common law jurisdictions about not guilty by insanity, they all arise from political assassinations. So I just thought you might find it interesting and relevant. So let's go back. I want to take you back to 1843, and again, uncharacteristically, I have notes. In 1843, a guy called Daniel McNacton, and there's various ways that people spell his surname, he was out walking in London, and he approached somebody called Edward Drummond, who was Robert Peele's, that's the Prime Minister, he was his private secretary, sort of, like the Sir Humphrey type thing in Yes, Prime Minister. And he shot him dead. And apparently that's because he thought he was actually Robert Peele. But anyway, obviously he was put on trial for the murder, and this was in the old days when, that would have got him the ultimate penalty. Sorry to check this is still recording, yes. However, he pleaded insanity. Now, that was pretty much the first time that anybody had raised insanity as a defence in the modern form. I mean, throughout history, and I'll briefly mention it shortly, there have been various ways where they've said, OK, if people don't know what they're doing, is it right to punish them? But the jury actually acquitted him. They said, yeah, this guy's completely crazy, so we don't believe he knew what he was doing. Well, anyway, they found him not guilty. And that caused a bit of a public outcry, obviously, because, he had shot somebody and actually shot the wrong person, some poor innocent secretary. And it got to the stage where even Queen Victoria said, what's going on here? And she had a word with the government. So what happened was, this was before the Judicature Acts and when we formalised what we call the Supreme Court, which is now the Superior Court, and the House of Lords, which is now the Supreme Court. It's all very complicated. I did another video on that as to why the Supreme Court isn't part of the Supreme Court. But anyway, the House of Lords, as a parliamentary chamber, they had an old common law prerogative or constitutional prerogative to just ask questions of judges. So they went to some of the senior judiciary and said, I think this needs clarifying exactly how we deal with this. And they came up with something called the McNacton Rules, later codified into statute. This quite often happens. I mean, I wonder, actually, in the comments, let me know if there's any ex-old Bill out there who still remember the pre-Police and Criminal Evidence Act days when we used to call them the judge's rules. Well, I say we, I wasn't around at the time, obviously. But we had the McNacton rules. And what they said is that somebody would be not guilty of an offence, they would be legally insane if either they suffered from such defect of the mind that they didn't know what they were doing, or if they did know what they were doing, they did not know that what they were doing was wrong. And there was a bit of a debate as to, is that wrong in the legal sense or wrong in the moral sense? But that became the test. And that test was adopted all around common law jurisdictions. And if you were found to be legally insane, that was an absolute defence. You were just not guilty. Now, of course, now we have things like hospital orders. I mean, actually, McNacton himself, he was sent off to what eventually became, at first he was the old Bethlehem Hospital, the one just off Liverpool Street, and indeed what used to be the Imperial War Museum. That was the original Bethlehem. I know you like trivia and tangents, well, I hope you do. And then he later ended up in what is now Broadmoor. So it's not like he got off scot-free. But yeah, that's the sort of the insanity rules. Now, that has to be contrasted with, there's another defence that sometimes gets me called automatism. And that's another complete defence to a criminal case. And that's where it's an external factor that causes you not to be responsible for your actions. Now, the classic example is you're sort of driving along and a wasp or a bee flies through your window and you just instinctively swerve and have a car accident. Well, they've said, well, really, although you were steering the car and you were driving, you weren't really in control, were you? Because you're reacting to the external force. But some medical conditions and psychiatric conditions, they can be triggered by external forces, and it gets very complicated. And all you criminal law students out there will be familiar with all the criminal law exams that are nearly always about people with diabetes. Because let's say that somebody goes into a coma because basically, they're not producing enough insulin, and they go into some sort of, situation where they're not in control of their actions. Well, because that's an internal factor, it's their diabetes, that actually counts as insanity. However, what if it's something like you accidentally take too much insulin, and then you have another reaction and you're not responsible? Well, that's an external factor, so that counts as automatism. Now, there is actually a case, although it's a first instance case, where a judge said, this is ridiculous that you call diabetics, you say diabetics are insane. If we're going to say people are not responsible for their actions, fine, fair enough, but let's just give it another name. And it's the fact that, it's so arbitrary, isn't it, that one defence is automatism, that no stigma attaches, and the other one is, oh, you are insane. Because automatism is, if it's automatism, you don't even get the hospital order or anything, because there's nothing to treat. You just walk away scot-free. But you're really going to bang somebody up, a diabetic up in an asylum, just because, they had a bit of a hyper or hypoglycemia. You'll be able to figure out which one's which yourselves. So, it's all very up in the air at the moment. Now, we also have something called diminished responsibility. That's only a defence to murder. And diminished responsibility is effectively where you have such abnormality of the mind that you weren't quite thinking straight. However, it's not a total defence. It's like, yes, you knew what you were doing a little bit. So in that case, that just turns murder into manslaughter. So it means it's not a mandatory life sentence, and the sentencing options are a lot wider. So what else have we got on this thing? Oh yeah, and now in America, interestingly, they actually thought the McNaughton test was a bit harsh, because it's quite hard to meet those criteria to say you don't know exactly what you're doing. And they said it's all things like, it should be that if it was illegal, if what you were doing even when you were like delusional would still be an offence, it shouldn't apply. So the classic example is you chop somebody's head off thinking you're cutting a loaf of bread. Well, that's fine, because you didn't think you were doing anything illegal. You shoot somebody because you think they're like aliens or demons. Well, technically you shouldn't be going around shooting aliens or demons, so it would still be an offence. So even though, you're not thinking straight, you have actually committed a crime. But in America, they use something called the ALI test. It's American Legal Institute model test. And that was a bit more sort of, friendly. It was a bit easier to meet that test. However, when John Hinckley shot President Reagan, there was a bit of an outrage because they applied the ALI test, and effectively they thought it was being treated very leniently, because there's all this thing where there's all the fuss every time I think he's actually out now, isn't he? Because I think he did actually get parole. So a lot of American states actually went back to the McNaughton rules because just basically there was a big public outcry of the grounds that people were getting away with all this. What other things can I talk about? The Law Commission in 2013 said this is a complete mess. And remember my video about they were asking for things about contempt of court and asking for advice and making proposals. They did that back in 2013 and said we really need to sort this out. However, although they have done some proposals and said maybe the judiciary should approach it this way, the judiciary have come back and said, if you want to change this, do it by legislation. We are not getting involved in this. We are not creating new law just through, stare decisis or precedent or common law procedures, whatever you want to call them. They said something this major that effectively decides whether people go to prison for life or go scot-free, let the government of the day take the stick if they're going to change that. Other things that are relevant, as I mentioned before with the Peter Sutcliffe case, the mere fact, now you can only declare somebody insane on the evidence of 2 psychiatrists, one of whom at least must be registered under Section 12 of the Mental Health Act, which is a particular qualification. However, as we've mentioned and has happened with Peter Sutcliffe, even if all the experts agree, the jury are perfectly entitled to say, well, bearing in mind all the other evidence we've heard, we still don't think he's insane, or we think even if he is insane, he knew what he was doing on this particular occasion. But there's another test that I really, really like, and that's called the policeman at the elbow test, which they apply in some American jurisdictions. And the test is, okay, you say you're crazy, but if there was a policeman stood next to you, would you still have done it, however crazy you're claiming to be? I mean, it's interesting this, because we've now got this like loss of self-restraint, loss of self-control thing that crops up in like DV cases. And people always point out that people say, oh, I couldn't control myself and it was a crime of passion. It's like, well, no, because you wouldn't have done that in public. You're doing it behind closed doors. So you clearly are applying some rationality to it. And I just like the fact that, you know, they've sort of formalised that in some American states. And I do like the idea of the policeman at the elbow. What other things can I talk about? Just to say, historically, even in the Middle Ages, they recognised that not everybody was responsible for their own actions. And okay, sometimes they say, oh, it's demons or possession. But even in sort of more secular times, and this goes back in a long way in some jurisdictions, you know, this goes back to the classical era in some cases. And they recognised that some people were just completely out of it, that they said this would be like trying a beast or an infant. Having done some babysitting, I'm not quite sure what the difference there is. So yeah, they said, you know, you wouldn't put an animal on trial for this, so why would you put a person, a human person? Although having said that, they also had that thing called deer dams, which was putting animals on trial, and indeed once a railway engine, but that's perhaps a tale for another time. But anyway, as always, hope you found that vaguely useful, vaguely interesting, hopefully not too vaguely distasteful or cashing in. Like I say, I'm sure Donald Trump would love me talking about him. But if you did, please consider liking, sharing or subscribing. Where am I today? I'm at Crantock again, in a thing called Crantock Round, which I'm always suspicious when you hear anything round, in case it's an old like Iron Age or Neolithic round. And I suspect this might have been at one stage, but it's just done like a little pretty park. But I'm going to shoot across in a minute and watch some football match. And also, you'll notice I'm wearing a different shirt. I do appreciate all the comments about the fact I always wear the same shirt. I do love that shirt, and I do need to replace it at some stage. But I thought I'd wear this one just to show I do actually own more than one shirt. And I specifically like this one because I was in Sierra Leone recently, as you may know, doing something with the lovely bench and bar over there. And as a thank you present, they had this shirt made for me. Which I love, but also because I've got slightly orangutangy arms, this is the only shirt that actually fits me. I was really tempted to go into Eden Ravenscroft and just go, see, it can be done.